let's talk about intellectual property, specifically some of the considerations that are raised by NFTs. Luckily, we have an expert. So without further ado, may I please get a warm welcome for John Delaney.
Everyone, thanks for that introduction. Okay, these issues normally take hours to cover, but 5 minutes, top 5 issues relating to intellectual property and NFTs. There's a lot more than 5, but these are the top 5 ones that we wrestle with every day. And this is for clients both on the brand and content creator side and also on the platform side. So number 1, from an IP perspective, and by IP I mean intellectual property, what do you obtain when you buy an NFT? Any thoughts? Do you own the copyright in the content that's associated with the NFT? What exactly do you own? Well, there's 3 possibilities. 1, you might own the copyright in the content associated with the NFT. So you actually become the copyright owner of that Bored Ape image that you paid $300,000 for at least 2 weeks ago. Or maybe you don't own the copyright, that the creator of the content owns the copyright, but you own a copy of the content that's associated with the NFT. So that's a possibility. Or maybe you have a license to make some kind of use of that content. And you may remember from some months ago, the Spiced Owl paid $3 million for the pitch book for a movie version of Dune that was never made. And they paid $3 million for it. They won the NFT. The script, pitch book was embedded in an NFT. And they announced they're going to start making the movie, crowdfunding a movie. Well, what was the problem? They thought Category 1 applied, but it turned out they didn't own the copyright. The copyright in the Dune characters and story is owned by the estate of the writer. They maybe had ownership of the copy, but probably at best they just had a license to make certain uses, maybe to display the pitch book in connection with their use of the NFT. So, in most cases, in fact, transferring ownership of copyrights turns out it's very difficult. You have to have a signed writing that's agreed to by the parties. You could do it through a click-wrap agreement, but you have to be intentional about it. It doesn't just happen. That's issue number 1. Issue number 2, survey says, if one is obtaining a license to the content associated with the NFT that you bought, what's the scope of that license? And this is a great issue because many times there is no license. It's just unclear. Can you, and go to the next slide. Do you have exclusive rights to that image or non-exclusive? If you have non-exclusive, that means the content owner could issue more NFTs with the exact same image. Are you allowed to make commercial use, or are you limited to non-commercial use? If there's no license terms, you don't know. It's unclear, right? Do you have a right to copy the image? Do you have a right to publicly display it? These are rights typically you need to obtain from the copyright owner. Can you modify it? Can you use the content off token? Could you create a 3D plush toy based on the content associated with the token? So the pro tip is, and this is becoming standard even though the industry is so nascent, to actually set out the terms and conditions so the user, the buyer, knows what it is they're obtaining. Which leads us to issue number 3. Okay, so the initial sale, the buyer sees the licensing terms, or maybe click accept at the terms and conditions of the selling platform. But what about downstream buyers? How are they going to be bound or subject to the licensing terms? Well, the law in the US is, the licensing terms need to be clear, and you need to get clear and conspicuous notice. You need to have an opportunity to review those terms, and there needs to be some indicia of consent to be bound. So if it's on a platform and you click their terms of service, okay, well, you're bound by that, but what if the token is sold on a different platform with a different set of terms and conditions? Issue 4, what if the NFT's associated content infringes a third party's intellectual property rights? This is a difficult issue, right? We want the token content to be available forever, persistent. But if you get a takedown notice and you're the issuer of the token and you're unable to remove the content, let's say you've stored it off-chain in AWS or the IPFS, you don't get the benefit of the safe harbor immunity from copyright damages. But however, if you remove the content, the users who paid money for that content associated with the token is going to be upset at you. It might be consumer protection issues. So again, set it all out in a set of terms and conditions that you try to make binding not just on the initial buyer, but on downstream buyers. And then finally, issue number 5, we'll end with this. The Copyright Office in this country, believe it or not, says Naruto, this ape who took a selfie of himself, that photograph is not protected by copyright. Anyone is free to use it because Naruto is not human, and according to the Copyright Office, only humans can create copyrightable works. Okay, well, what if we have AI or machine-generated images for tokens or variations on an initial image, or it's created by algorithms or by code or by AI? Is there any copyright at all? And if there's no copyright at all, what's to stop anyone else from issuing NFTs with the exact same image? So food for thought, lots of issues there, 5 issues in 5 minutes. Thank you very much.